MBE questions, and yours were renumbered 21, and your answer sheet comes back.
Were they supposed to send a half number?
I had 2 of you, and then whoever gave it to me first, I did it.
I gave you 21 through 41.
You gave me 41 through 61.
I did.
Yeah, so I renumbered them. That's okay, I figured it out.
Must have had a bad hair day.
Okay, so who's on? Trish? Oh, I was trying to say.
Let's sign in, guys.
Oh.
So kind of long.
Yeah, I gotta go hand out home. Yours is here. Or you're just, you're like Professor Evans. Oh, Clara's on there.
I want to see.
Yeah, so does Evans.
They didn't do very well either. Yeah. Okay.
Okay, you have 2 online, so I'll give those up to them. What? They're in there. No. Oh. Will do. Here's your MBE for tonight.
Oh, Clara's
Yeah,
attending.
I took it, I saw her.
Okay, you
Here's
took
your
it?
MBE.
Can I get her?
Yes.
Okay.
And that, I showed you that every night. Okay, and then the last 5.
And what about Brian? Is he coming?
He's here.
Yeah. So I remembered your answers. Oh, okay. I'll share. I had up for home.
Oh, shit.
I'm convinced really has an
Yeah. I had it.
Okay, I just sent you guys, Clara and Trish, I just sent you the question and the model answer. And Rebecca is sending you your papers.
Thank you. Thank you.
So you can see what your grade is. So. Okay, guys. Overall, the essay looked pretty good. One of you two looked like you didn't finish. Like you ran out of time or something. You don't get points for running out of time. So at any rate, that will explain the grade you got. Someone else had difficulty. Serious difficulty. That person should email me or contact me by telephone, by cell phone tomorrow or sometime next week, and I have a project for you to bring up your grade. Okay? So with that, let's actually go through did that question look familiar?
A little bit.
Okay, that question was the question I told you to look at. That was a bar exam question in 2012. And if you did that and you studied it, then you should have been able to answer it. Okay, whether you used my outline or not. Just so you know, when I tell you to look at something and to study it, I don't have a hidden agenda. Okay, I'm not just telling you to look at it as a matter of interest. When you start, if you study for the bar exam, I don't know what the baby bar is like. I don't know anything about the baby bar.
It sucks.
I don't want anything to do with the baby bar. But you can if you start looking at annually, they repeat questions. Like that 2012 question is repeated. I don't know whether it might be repeated the very next bar exam. So they have no compunction in giving you a question that's already been given that you can find and see what the right answer is supposed to look like. Okay, it's like going to the DMV, right? And you can get their handout online or at the DMV, right? And then you can go online, and if you pay $15 or something like that, they have a whole bunch of sample questions, right? And the sample questions, it turns out, aren't sample questions.
They're the exact same.
They're the exact same questions that you're going to get when you go to the DMV. And if there's 20 questions at the DMV, they give you like 150 questions. And a lot of them are repeats. And I mean, you're just sitting there and say, oh, I know this one. So, the idea is you're going to learn something if you study all these questions. Now, in addition to looking at a bar exam question that's an essay question, I didn't go over a lot of multiple choice questions with you guys. I just gave you some samples at the end. And that showed, because you guys didn't do well on choice questions, which isn't unusual. Okay, I don't know how you guys did last year on the MBEs. You're shaking your head.
Not good.
Not good.
Yeah. I mean, basically 50% right now. I was just looking at the constitutional law ones, and they were coming in like 50%. Okay, and that's Anise and Cole and those are smart guys. Okay, and they're coming in at 50%. And common law is just like jurisdiction. Okay, so people find that subject especially difficult. Okay, so what I think we're going to do in the future is starting next week. Everybody read the assignment for this week, right? Okay, there's not much in that. That's a lot of fluff. Okay, I'll tell you what to take home. Okay, there's like two items that you'll ever be tested on. All right. So I think starting next week, I'll start giving you 5 multiple choice questions at the end of whatever it is that we're covering that hopefully covers that subject. All right? The only question I have is, do you want to do them in class, or would you prefer to take them home and do them, and then we'll go over the answers the following week? That way it's kind of like an open book test, unless of course we've got the time. I mean, if it's like, 8:30 and we need to get to 9 o'clock, then we'll just do the 5 questions. But if we're getting close to 9 o'clock, if you guys would prefer, I'll give it to you. You guys can do an open book. It's open book anyway.
Yeah.
All right.
As long as we can go over them in class, like go
Yeah.
over the answers, I think that's the most important part, is going over why
Well,
each
we
one's
will.
wrong, yeah.
We will. I mean, I don't know that on the questions that you got this time, I don't know that I can do that. I've got the book with the questions, but I didn't write down the numbers, and they've all been renumbered. Because they're not, when you do these questions, they're in a book of like 150 questions, and they're all mixed up, okay, in different subjects. And like all the jurisdiction ones and Erie ones, I didn't use. I only used some of them. And then when I gave them to Veronica to put in test form, then she renumbers them anyway. So I should have kept a track, but I didn't. But we can look and see what the right answer is, and that's kind of, it's tucked in the question. So let's go over, first of all, let's go over the essay, okay? And you guys, or won't we? What did I do here? You guys have it on your computers, right? Trish?
I'm still getting it.
Okay.
I have the model answer. I have the model answer.
Okay, you got the answer? Okay. So here's the question and the model answer. So I think before we talk about it, why don't you read the model answer? Now, this model answer is different than what was on the state bar. That's my version of it, taking whatever the person who wrote this answer, and then I reworked it a little bit, and I put it in a format that all of the bar review courses say they want you to use. And I can tell you, just looking at this, you can see how easy it is to read it, and taking into consideration that for the state bar exam, they take about 2 minutes per paper. Okay, you really have to do it like this. You need headers with issues, and then topics and conclusions. So take a look at that.
Mhm.
Are we trapped in here? Okay, there we go. That's good. What you got?
Okay.
Oh, you're just giving me back to me?
Yes, these are the essays. In here.
All right.
You should both have received your email with your essays and your MB.
All right. Everybody read it? Everybody's done? Any questions? Going once? All right. So let's collect those. Okay, you guys have the civil procedure, the multiple choice?
Have the email, but it's not letting me open. It's not going through.
It's what?
It's not opening.
What about you? Trish, can you open it?
Mine worked. Mine worked. Did you double click on it, Clara?
Yeah, I tried that. It's not letting me. It's not doing anything.
Huh.
Should we get Veronica?
What?
Should we get Veronica?
Yeah, I got Veronica's email and I got
What's your,
professors.
what browser are you using?
I have well, I have AOL, but I got both your emails. It's just not opening. The attachments aren't opening.
And you got AOL as your email. Use another browser? What kind of computer do you have?
Toshiba.
So.
I don't know if it's just a delay. It's never done a delay
You know what
before.
I mean by a browser?
Are you using Internet Explorer or Chrome?
Chrome.
Do you have Internet Explorer?
Yes.
Yes. you
Try
got it.
that.
Try that one, yeah.
It comes with the Toshiba.
Yeah.
Try Internet Explorer before we get Veronica. Firefox is good too.
Firefox is good.
I just use Chrome notes. Really easy. I figured out why they say that MacBooks don't get, and Macs don't get antivirus and firmware and stuff. It is because they're any better. It's because they don't use Internet Explorer, and most of those viruses and firmware and things like that are written for Internet Explorer.
Interesting.
How are you doing?
To me?
It's trying.
I think it's your internet.
I have Spectrum. I usually don't have any problems with Spectrum.
You have Spectrum?
Yeah.
Well, that's cable, right? You got cable?
Yeah, but it's also with internet. Okay, so I have the multis came up, but not the essay.
No, forget the essay.
Okay.
We already did the essay. Okay.
Okay.
So you got the multiple choice now, right? Everybody's got the multiple choice, because what we'll do is we'll just start with Daniel, and each one of you will read a question, then we'll go back and start over again. Wake me when you're done. Okay, so okay. Let's, what's our number?
21.
21? Okay.
Yeah.
So, Daniel, you start.
A woman, a citizen of state A, was involved in a car accident where she negligently injured the driver and passenger via the car. Both the other driver and passenger are residents of state B. The other driver filed a lawsuit against the woman alleging $30,000 in damages, while the passenger filed a lawsuit against the woman alleging $50,000 in damages. The plaintiffs wish to bring their action in federal court. Does the federal court have jurisdiction?
What's the answer?
I chose A, but I got this wrong. I chose A, yes, because the federal court has a diversity jurisdiction over the matter.
Okay, well, it's not B. Is it?
No, it's not B.
Okay,
I thought they could aggregate their claims, so that's
so
why
is it, what's the answer?
the answer is D, as in dog.
Okay,
The answer is no, because one plaintiff is only alleging $50,000 in damages and the other is only alleging $30,000.
okay. And how many people chose D? Did anybody choose D? Trish and Clara chose D. Okay. All right, that's an aggregation issue. All right.
I still don't understand why it doesn't aggregate.
Okay, the driver filed a lawsuit against the woman alleging $30,000 in damages, while the passenger filed a lawsuit against the woman alleging $50,000.
And they were both injured in the same accident.
Right. So it looks like A could be right, but we don't know, we actually don't know enough about it. I think that's, huh?
I said it's arguable.
I think it's arguable too. I'm not sure that I like that answer.
Well, I got rid of, the way I analyzed it is I got rid of the two no's because I was like, well, yeah, they have,
Well,
it's met the jurisdictional amount, right? But it hasn't,
no, and the accident occurred in state B is irrelevant. Yes, this isn't a federal question, so the only issue is A or D. Right, and it's an aggregation. And if it arises out of the same
case or controversy,
controversy, then,
which it does.
yeah, which it does, then I think the answer, I would have answered A. So let's, we'll see how many we come up with, okay? I don't like that answer. I'm gonna just, right, we can beef a couple, but we can't beef a whole lot, okay?
I just don't know how you could pick D.
Well,
Well, like for the reason, no, because one plaintiff is only alleging 50,000.
okay, guys,
Why'd you pick D?
why did you pick D?
Because I thought it was classic diversity issue.
They couldn't aggregate.
Yeah.
Okay.
Well,
All right. So let's see. I'm gonna look at the answers on that one. And I may beat that one. Okay, let's go to 22.
Okay. Which of the following statements is correct? The plaintiff, a citizen of state Z, sued Bilko, a large state A corporation doing business only in state A. The action asserted that Bilko had failed to provide support and service for a $86,000 recording system that Bilko had sold to the plaintiff. The plaintiff sued Bilko in the U.S. District Court in state Z. Although the contract was accepted and signed in state A, there was a provision that stipulated that in the event of the litigation, Bilko could be sued by the plaintiff in state Z. Bilko moved for transfer of the action to U.S. District Court in state A, claiming that its support and service personnel who would be witnesses are domiciled in state A. The state A damage remedies are more favorable to Bilko than the corresponding rules in state Z. Which of the following statements is correct?
No,
Well, I see the answer is B, but I had chose D.
what does it say, D?
The incorrect answer I chose, which is D. The provision stipulating that Bilko was central in state Z is unconstitutional. Bilko's motion to transfer the action to the U.S. District Court in state A will be granted. The correct answer was, if Bilko's motion is granted, the law of state Z regarding damages will be applied.
That's the correct answer.
Mhm.
Do you understand why?
No.
It's an eerie question. Okay, look, so although the contract was accepted and signed in state A, there was a provision that stipulated in the event of litigation, Bilko could be sued by the plaintiff in state C. Okay. Bilko moved to transfer, blah, blah, blah. The damage remedies in state A are more favorable to Bilko. Okay,
So they're trying to prevent forum shopping,
yeah,
right?
you get it?
Yeah, I figured it out. Thank you.
Okay. 23.
The plaintiff, a citizen of state A, was involved in an auto accident with the defendant, a citizen of state B. The accident occurred in state A. Pursuant to the applicable state A long-arm statute, the plaintiff sued the defendant in state A state court of general jurisdiction for $80,000. The plaintiff also named the defendant's insured. Pursuant to state A law, this type of action was permissible. The insurer was incorporated in state C and had its principal place of business in state A. The defendant seeks to move the case to the applicable U.S. District Court. Should a court grant or deny the defendant's request? So,
What's the correct
the
answer?
correct answer here is D. The court should deny the defendant's request because insurance principal place of business is in state A.
What?
The answer is D.
D. Did you say C?
No, I said D.
D.
As in dog.
I was gonna, what? C?
I chose A here actually. I looked at the amount of controversy instead.
Okay,
The
but
principal place of business.
there's an example of how you really gotta be careful with the jurisdiction question. You gotta look at all the facts. Right?
Right.
Do you understand why the answer is D?
Not exactly.
All right. Plaintiff's a citizen of state A, right? Let's go to the insurer. The insurer was incorporated in state C and had its principal place of business in state A.
Okay.
What does that mean?
It's just not diversity.
It's a citizen of state A for purposes of diversity. What happens when you have two parties that are from the same state?
That's their.
It defeats diversity. Okay, that's what.
So the $80,000.
Doesn't matter, it's irrelevant.
Okay.
You only get to $80,000 if they're citizens of different state.
So you're gotcha.
Okay? Yeah, okay, 24, Clara.
Okay, in 2003, a state A resident purchased a life insurance policy from Insure Life, a state B corporation. In 2008, USA Corp agreed to assume Insure Life's insurance obligations. USA Corp then mailed a e-insurance certificate to the state A resident offering to insure him in accordance with the terms of the policy he held with Insure Life. He accepted this offer, and from that time until his death in 2014, paid premiums by mail from his state A home to USA Corp state A office. The man's mother was beneficiary under the policy. She sent proof of his death to USA Corp, but it refused to pay, claiming the man had committed suicide. Neither Insure Life nor USA Corp ever had any agent or any office or agent in state A. Additionally, USA Corp never solicited or did any insurance business in state A apart from the policy involved here. The man's mother sued in state A court. USA Corp claimed that it was not subject to the state A court's jurisdiction. Can USA Corp be sued in state A court? And I put B, that yes, because USA Corp solicited the man and collected his premiums. I think that's the correct answer.
Here, additionally, USA Corp never solicited or did any insurance business in state A, apart from the policy involved here. So, I mean, you go up to the top.
Right, and they actually, when you're, my reasoning was you were collecting premiums.
In 2008, USA Corp agreed to assume Insure Life's insurance obligations. It then emailed a certificate to state A resident offering to insure him. Isn't that a solicitation?
Yes.
So they threw in a red herring where it says USA Corp never solicited or did any insurance business in state A, but then it says apart from the policy involved here. So it's saying right there that they solicited. So what case is this?
When the mother is trying to collect her son.
This is a Texas case.
Yeah, where's California?
Yeah, does Texas solicit, it's almost the same, identical facts. So what's the answer?
B.
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 Yes. It's that case. Okay? All right, Trish, 25.
Okay, a man sued a doctor in federal court for malpractice that occurred when the doctor operated on him. The man claimed $100,000 in damages. The man also wanted to join a related state malpractice claim against a nurse who assisted the doctor during the surgery. The man claimed $80,000 in damages against the nurse. The man was domiciled in state A, the doctor was domiciled in state B, and the nurse was domiciled in state A. Can the man join the malpractice claim against the nurse? 25. I picked A, but I know that the answer is B.
Is what?
D as in dog.
Okay.
I picked A because I did think it was related and thought it was the same case of controversy.
It doesn't matter if you want to bring a party in who's in the same state as the plaintiff, you can't do it. That would defeat diversity, right?
Right, I see that now. That's weird. Yeah.
Okay. Go back to Daniel.
All right. If the consultant seeks to remove the case to the federal district court, will he be successful? Tricorp, a small corporation focusing on the production of solar power devices, filed suit in the state court of State A against a former consultant that had worked as an independent contractor for the company arguing that he had violated federal patent law by using Tricorp's design in his own work, and that he had also overcharged Tricorp for his work, which was an alleged violation of state aid contract law. Both claims arose out of the same work conducted by the consultant. The total damages sought by Tricorp were $75,000. Tricorp's principal place of business was state A and was incorporated in state A, or state B. The consultant was a resident of state B. If the consultant seeks to remove the case to federal district court, will he be successful?
What's the answer?
The answer is A. And I chose C because the amount of controversy must exceed 75,000, and here it said it was 75,000. There was diversity, but the federal amount has to be in excess of 75,000. So that's why I chose C.
Yep. You chose what?
I chose C. No, because the amount in controversy must exceed $75,000, and it says the total damages sought by Tricorp were $75,000.
I'm gonna beat that one too. That's just wrong.
I agree. I got four.
How many people got C? How many people did A?
Oh, well, I'm
Okay.
sorry, what time, was that, is that 26?
Who did, yeah.
Is that
20
question?
Did anybody
Yeah, I
pick?
picked C. I picked C also.
Okay, I think this is just wrong. Well, teach me not to read the whole question and answer. Okay, I'm gonna beat this one too.
Yeah.
All right, 27.
Should the action be removed? A vacant citizen of state A filed suit against the butcher in a state A court alleging a claim based upon a federal statute. The butcher, also a citizen of state A, filed a petition for removal to the federal court, which encompasses the judicial district in which the state court is located. Should the action be removed? Yes, the baker's action arises under a U.S. statute, which is what I chose.
That's right. Anybody get that wrong?
Yeah, I put C.
You put C?
Yeah, I know why I got it wrong.
I mean, that's the right answer, guys. Yeah. Anybody else get that one wrong?
I
Okay.
did, but I know what I did.
Yeah, I mean, it says right there, pursuant to a federal statute, that's a federal question, that your court has jurisdiction, and to remove it. Okay.
Has the court
28.
Has the court acted accordingly? Professor at a state university sues her employer in federal court on the basis that the university's code of conduct forbidding professors to attend political fundraisers violates her First Amendment right to free association. The university, in answering the professor's counterclaims against the professor, the university's payroll department has undercharged the professor for her health insurance contribution over several years and now seeks to collect $20,000 in repayment. The court uses the federal rules of civil procedure when deciding the First Amendment claim, but the state civil procedure code in deciding the state claim. Has the court acted correctly? Answer is D, no, because federal courts must always use the federal rules of civil procedure in civil cases. Answer is D.
Is what?
D.
Anybody think that's not right?
I thought there was times when the federal court could use state law.
It can't. But the university, let's just go back and look at it. Yeah, it says, but the court uses the federal rules of civil procedure when deciding the First Amendment claim, but the state civil procedure code in deciding the state claim. Has the court acted correctly? No. Whenever the issue is procedural, what does the court do?
Federal
Federal.
rules.
Yeah. So it doesn't use state civil procedure, ever,
Okay.
ever. It can use state substantive law. Okay? Get it? All right. 29.
A candy company, a state A corporation with its principal place of business in state B, was sued by 5 of its buyers in a class action that alleges that the company overcharged them and 5,000 others in their states for sugar. The action sought a refund of the overcharges. The plaintiff in the action are April A, a citizen of state C, Bart B, a student who is domiciled in state C but is attending law school in state D, Chris C, a citizen of state E, Diana D, a citizen of state A, and Erica E, a citizen of state F. The amounts of the overcharges claimed by the named plaintiffs are A, 15,000, B, 10, C, 80, D, 29, and E, 14. Which of the following is true? And it should be C. The federal court has subject matter jurisdiction if the aggregated claims of the class as a whole exceeds 5 mil. I put D because I couldn't remember, so I left out an extra 0, so it should have been 5.
What?
It should have been C, 5 million.
That's right. Okay. Yeah. Okay. 30, Trish.
30. A woman who lived in state A sued a man for battery when she got hurt in a bar fight that he started. She is suing for $40,000 for her injuries. In the same suit, she also claims $50,000 in punitive damages. She sued in federal court claiming diversity jurisdiction. The relevant state law barred punitive damages in actions of this type. Can the woman's action be heard in federal court? The answer is C, no, because the claim is legally certain to be less than $75,000.
Anybody think that's not?
I got that right.
$50,000 in punitive damages. Punitive damages, she can ask for $50 million in punitive damages. That's not the issue. You can't aggregate punitive. How about this? You can't aggregate punitive damages with compensatory damages. The issue is compensatory damages, not punitive damages. Punitive damages aren't certain. Okay? 31.
A supermarket became involved in a labor dispute with the plumbers union, the entity that ordinarily supplied workers for the supermarket's plant. The supermarket commenced an action against the union in the appropriate U.S. District Court, claiming $75,000 in damages as a consequence of the union's conduct in harassing and intimidating non-union workers in violation of the Federal National Labor Relations Act and applicable state law. The supermarket is a state A corporation, and the union, an unincorporated association, members who are domiciled in every state except state B and state C. The union answered by denying the supermarket's allegations and filing a $25,000 counterclaim. Counterclaim asserted that the supermarket had deliberately made false accusations about the union to the local news station. If the union moves to dismiss for lack of subject matter jurisdiction, should the court grant the motion? And the answer is C, no, because subject matter jurisdiction is satisfied.
Why? They say C.
They say C.
Did anybody put D?
I picked A because of that excess. It wasn't, it's in the back pattern.
Not even close. Remember I told you that if they sue pursuant to a federal statute or the Constitution, that diversity isn't an issue. That's a
Right.
So then the court has subject matter jurisdiction. But
Yeah.
so that's the answer, C. It
Yeah.
doesn't say federal question, but that's the answer. Did anybody put C? You did. Okay.
May the woman sue the company in federal court. A company's hand moisturizer caused a woman's fingernails to turn green. She could not get the color out no matter how hard she tried. The woman sued the company in federal court for negligence, claiming that.
Wait a second. What's the problem with your fingernails turning green?
It's like,
Depends what kind of green.
yeah, it's like,
She didn't like the color. Okay,
Bring it up here.
couldn't she just take fingernail another color and put it over?
yeah.
Okay, never mind.
Okay, so the woman sued the company in federal court for negligence, claiming that the company sold a defective product and failed to follow the labeling standards required under the Federal Drug and Cosmetics Act. In its language, the FDCA did not specifically authorize parties to sue for damages when they claimed injury from a failure to comply with labeling regulations. May the woman sue the company in federal court? The answer is no, because the FDCA does not specifically provide for a cause of action. I chose A, yes, because her lawsuit involves federal questions, so specific language is not necessary.
What did you put?
I chose A.
Wait a minute. They sued in federal court for negligence, right?
Yes.
It says right here in its language, the FDCA did not specifically authorize parties to sue for damages. See it?
Yeah, I just thought the issue was failing to comply with the labeling regulations.
Doesn't matter.
Yeah, but
If it's not authorized by statute, then that's just, what that means is that you can use the federal statute as evidence of what the standard of care should be for negligence, but they're not suing pursuant to the statute. It's just that it's a negligence case, okay? It's kind of a tricky question, but you understand?
yeah, I get it.
Okay, 33.
Would the man be able to pursue such special damages in his claim? The man was injured and his business was destroyed when a small plane crashed into an office park in State A. He sued the airline in federal court in State A under the Federal Airline Act, which authorized federal suits for damages arising from airplane crashes. He also filed a state law claim against the airline for negligence. In the state law claim, the man asked for special damages related to potential lost business opportunities. The majority of states did not allow such damages, but State A and a minority of other states did. Federal common law subject was unclear, as Congress had not expressly allowed such damages in civil several other claims. Here I chose B.
Well, wait a minute. Okay, so the question is, would the man be able to pursue such special damages in his claim? What's the right answer?
The right answer is actually A, yes, because federal jurisdiction over the claim is based on supplemental jurisdiction. Forget what that meant, so just B.
Well, you know what supplemental jurisdiction is, right?
I forget what.
You forgot what supplemental jurisdiction is? Did you just read the answer to the essay?
Yes. No, I meant when I answered it, I forgot it at the time.
Oh.
Yeah.
Well, forgetting it isn't it?
No, I did not answer.
That, okay. Next, does everybody understand that answer?
Yes.
Okay. Next, Clara.
34. So a man was a resident of state A and wanted to sue a car manufacturer in federal court based on diversity jurisdiction. The car manufacturer was incorporated in state B, had its home office and factories in state C, and conducted business in many states, including state A. May the man bring his suit in federal court? And I got that as B, yes, because there is complete diversity between the parties.
Well, what's the answer?
B,
Huh?
B,
Oh, you did get it right.
yeah, I got it right.
Okay, anybody think that's not right?
I
That was an easy one. That was an easy one.
Yeah, that's a throwaway. That's a throwaway. The fact that it the fact that it conducted business in state A didn't, without knowing more, right? Okay.
35.
35.
A man had a flower shop built in state A and was planning to move to state A in 3 days when the flower shop was to be open for business. He also bought a house in state A and was living in his house in state B, which was to be sold next month while he made the preparations for the move. As the man was about to drive a moving truck with the last of his belongings from his house in state B, he was hit by a car driven by a state B resident. The man sued for damages in federal court, claiming diversity jurisdiction based on the fact that there was over $75,000 in damages. The car driver was a state B resident, and the man was now a state A resident since he owned a home there, and had most of his things there and intended to move there permanently. Can the man bring a suit in federal court? The answer is C, no, because the man was not physically in state A. And I picked B, yes, because the man intends to remain in state A permanently.
Where does it say that?
All over the question.
He had a flower shop in state A, and he was planning to move to state A. He bought a house in state A, but he was living in his house in state B, which he had to sell while he finished his preparations.
I thought, you know what, because C did not say, C says because the man was not physically, it doesn't say anything about domicile. He was actually physically at his flower shop, but I think that C could have said something like he's not domiciled instead of physically, because he was.
The mere fact that he intends on going to state B doesn't mean anything.
Even if he packed up his stuff and he's driving a moving truck with the last of his belongings, it's all that the intent to remain. There's so many facts that he had intent to permanently remain in state A.
Yeah.
There were very little facts saying that he was living in state B and going to stay in state B. what would be the argument that he's domiciled in state
Okay,
B?
the man, let's just like, the man sued for damages in federal court, claiming diversity jurisdiction based on the fact that there was over 75,000 in damages. The car driver was a state B resident. And the man was now the man, meaning the plaintiff, was now a state A resident since he owned a home there, had most of his things there, and intended to move there permanently in the next few days.
Oh, is it
So how
that
can it not be?
before he can bring it?
No, where he got, the accident was in state A. Okay? Get it? Accident state A. He's in state A. He's still got a house in state A. Right?
Yeah.
He's about to become a resident of state B.
No, he's
No, he's about to become a resident of state A.
yeah.
What?
Says he's about
He
to.
owns, so he's living in
I'm
his,
sorry.
he's living in his home in state B, but he just bought a house in state A and is intending to move there permanently because he also has a flower shop in state A.
Right.
And the accident happens in state B.
Oh, in state B, I'm sorry.
That's
Yeah,
what the problem is.
I'm sorry, I got the states. That's the problem.
But he owned a home in state A, had most of his things intended to move there and to stay there
Yeah, but where did this happen?
in state B, which is why there's jurisdiction or diversity.
Yeah,
So it should be removed to federal
and he
court.
was living in his house in state B. So at the time that this accident occurred, he's in state B where his house is. And the driver of the car is from state B.
Yeah.
It's tricky. I don't like the answer
That's
Yeah,
because the man was not physically in state A.
yeah, because
Yeah.
it's in the facts. The man was now a state A resident.
Where's it say that?
The
Right, so domicile is the important thing.
And the man was now a state A resident. The second line from the bottom. The car driver was a state B resident, and the man was now a state A resident.
Was now a state A resident.
Yeah.
Are you saying that because at the time of the accident, and now they're saying that the federal court now after the accident he is in a state A resident?
What were your answers?
B.
What?
B as in boy. B as in boy.
I think it also had something to do with the wording of the
Wait a
answer.
minute, what was your answer?
B, as in boy.
What was your answer? Clara, what was your answer?
Oh, mine was way off. I got A.
Forget that. Okay, I'm gonna say that I think that if you put B down, you should get it.
Yay!
A. I think it's the wording of the answer in C too.
Well, it's certainly arguable. I think if it's arguable, you get it. And the wording's a little bit tough. This is why I don't like multiple choice questions.
I hear you.
Well, it's like what I said, I didn't write these questions. It is what it is.
Yeah.
Okay, and unfortunately, the state bar doesn't do this. So, you really gotta read these things carefully, especially in civil procedure, because they got all these people in different states and jurisdictional amounts and all that stuff. Okay, who's up?
I think it's me. Okay, should the leader's motion be granted by the district court? A state district attorney filed a complaint in the proper U.S. District Court seeking to enjoin a religious demonstration. Although his claim alleged that the defendants had failed to obtain a license as required by state law, the district attorney asserted federal question jurisdiction by alleging that the defendants have publicly claimed immunity for such demonstrations on First Amendment grounds. The group leader filed a Federal Rules of Civil Procedure 12B1 motion to dismiss for lack of subject matter jurisdiction. The leader alternatively claimed immunity from prosecution under the First Amendment as an affirmative defense. Should the leader's motion be granted by the district court?
Answer?
The answer is A, yes, because there's no subject matter jurisdiction. And I chose C, no, because there's a federal question subject matter jurisdiction, because it's a First Amendment.
Wait a minute, let's go back. Although his claim alleged,
Well, because it's saying
wait a
that
minute,
it
because of,
says the First Amendment as a defense, and we had said.
yeah, you can't do
as a
that,
defense.
remember?
Yeah, no, I know why I got it wrong.
All right, that's Penwire versus Neff.
Yeah.
Right?
I'm sure.
Yeah, you can't plead, you can't plead a federal question by alleging a defense
Yeah.
of a federal statute or the Constitution. Okay, next.
In the case properly, is the case properly before the federal court? A man sued a bartender and a police officer in federal court after a bar fight. The man was a citizen of state A, the bartender was a citizen of state B, and the police officer was a citizen of state A. The man sued the bartender for assault and battery under state law and the police officer for violation of his federal civil rights. The man claimed $40,000 in damages. Is the case properly before the federal court? And the answer is yes, because of the civil rights claim.
Okay. There you go. Anybody think that's not right? Did everybody get that right?
No.
Daniel?
No.
No.
No, I chose C.
Sorry.
Yeah.
Isn't that what I warned you against? If it's a federal question, all that other stuff's irrelevant.
Yeah,
Those are tricky questions.
no, it's not even a tricky question, I'm just.
It is a tricky question. They throw in all these diversity issues,
Yeah.
but if there's a civil rights,
But it's a civil rights, like if I,
that's a federal question.
it's always when you slow down and you read these and you go over them slowly, and you realize that.
Yeah, read the whole question. Okay, 38.
A man, a citizen of state A, bought a cheese package from a company located in state B, which would ship its specialty cheese to him every month. We only sold these monthly cheese packages to customers in states and had no customers or business interests in any other states. Several years later, the man moved to state E. The man retained a monthly cheese package, and the company continued to take units and make deliveries to the man in state E, although it had no other customers in state E. The man then sued the company in state E court for strict liability when he had to go to the hospital for food poisoning. Does the state E court have personal jurisdiction over the company? The answer to that is A, yes, because the company delivered the cheese to state E.
Anybody think that's not right? How many people got that right? Everybody got that one.
I got that one.
You got that wrong?
Yeah.
I don't know what you were thinking.
I don't know, I think.
Okay. I don't know why everybody keeps saying, I chose the wrong answer.
Because you're asked.
No, that one I asked, but because I thought that was a gimme. Okay, 39.
A plaintiff, a citizen of Texas, filed an action in the U.S. District Court in Houston against D Corp., a Delaware corporation, and Z Corp., a Pennsylvania corporation, alleging that they were engaged in a violation of a federal antitrust act, and that his actual damages from the conduct of the defendants was $53,000. The plaintiff further alleged in a second cause of action that D Corp was wrongfully withholding $2,000 that the plaintiff paid to D Corp as a deposit for goods that were not delivered. Which of the following is true? The correct answer is B. The district court may exercise pendent jurisdiction over the second cause of action, but only if it arises from a common nucleus of operation facts with the first cause of action.
Everybody get that wrong? Everybody get that right?
Yep.
You asked.
I put B.
You asked. I got it wrong.
You got it
I
wrong?
got it wrong, yeah. I picked, this is what, 39, right?
Yeah,
39, I got A.
good for you.
You're the one asking.
The only thing that's at all tricky in here is that they refer to it as pendant jurisdiction instead of supplemental jurisdiction. Okay? And Trish, the last
40.
one.
Okay. A woman sued a builder in federal court under diversity jurisdiction. The claim was for damages under state law. The woman served process by having the summons and complaint delivered to the builder's wife at the home shared by the builder and his wife. In the builder's state, the state rules of civil procedure require personal service of process. The builder made a timely motion to dismiss the federal case for insufficient service of process. Should the court grant the motion to dismiss for insufficient service of process? The correct answer is C, no, because the federal court must apply federal procedure when there is a federal rule that covers the issue.
Okay, anybody have a problem with that one?
No.
Everybody get that right? No. No.
No, I didn't.
What did you put?
I put B. I didn't know my Erie well before this exam.
I told you guys Erie was gonna be on it, didn't I?
You did.
Didn't I say be in the multiple choice?
5 questions, yep. You did.
Okay, guys. All right, so how many people put A for 21?
I put B.
No, A.
Oh.
2? All right, how many people put C for 26? 3. How many people put B for 35? Oops, I asked it the wrong way. Yeah, how many
B
people
for
put 35?
B for number 35.
2? Okay, so that changes, does that do anything for you guys? Do something. Huh?
Something.
Okay, so let me have the exam questions.
But if we did pick D as in dog on the first one, we don't get penalized because we picked the right answer, right?
If you picked the answer that they gave, we're not taking it away. I'm just saying, if you did.
Okay.
If you put that, on those three questions, if you put that answer down, the word that I've circled, then you're gonna get
Yeah.
credit. We're not gonna,
Okay, cool.
we're not taking anything away.
Okay.
So even though you answered with the wrong answer. Okay, so let me have your stuff.
Up there.
Oh, did you put it up there?
Yeah.
All righty then. Okay, so we got 10 minutes before the break. What do you think the purpose of this chapter was? Other than collecting a hodgepodge of different kinds of information that don't fit in any of the other chapters.
I mean, how you charge for your fees? I don't know.
Huh?
Like the majority of it spoke about like contingent fees and
Yeah.
hourly fees, which
Yeah.
one would work better for the firm?
Well, a lot of this, yeah, but a lot of this stuff is the reality of daily practice in the law, okay? What's the most important thing in the practice of law?
They get paid, yeah.
What? Getting paid, right? Yeah. Getting paid.
I'll think justice.
What were you gonna say?
Just
Justice? Justice?
One's for the-
I was in a mediation. I was in a mediation in Santa Monica. On the eve of Yom Kippur, which is the holiest day in the Jewish religion, okay? And on Yom Kippur Eve, you're supposed to, go home be home by 5 o'clock. You gotta be there before sundown. And you're supposed to go to synagogue and pray, okay? And everybody, just serendipity, everybody in this case was Jewish. The parties were Jewish, all the lawyers were Jewish, and the judge was Jewish. And we're all sitting there. And I think the judge even said something about, what the hell are we all doing here on Yom Kippur Eve? And everybody laughed, ha, 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 ha. And we were trying to settle this case. So finally, at one point, we weren't getting anywhere. So the judge, usually, what the judge would do is first they'll get the plaintiff in there, and then they'll get the defendants in there separate. And they almost never have them in the judge's chambers together. First of all, the judge's chambers usually isn't big enough for everybody to be in, okay? But assuming that it was, that's the way judges do it. They usually, and most mediators will do the same thing as they separate the parties. Because they don't want to get, if it turns out that somebody's really emotional about it, they don't want to have people getting hit. So at some point, for some reason, he called everybody in there. And he was having problems with the plaintiff, who had been seriously injured the guy fell down some stairs, and the stairs were not, if the stairs had been built under current code, they weren't code. They were too narrow, they were too steep, there wasn't a handrail, okay? But they were built at a movie studio at the former MGM, and they were built like in the 20s, okay? Where they didn't have all these codes. So anyway, this guy falls down these stairs, and as a result of falling down the stairs, he had a head injury that basically rendered him almost paralyzed, because he would, if he tried to move, he got very, very dizzy and sick. Basically almost never moved. Okay, that was a really bad case. So the judge is in there, and he basically, and we were offering a lot of money. I represented the student. And the judge was trying to get this guy to settle. And he's in there with his wife. And the judge says to this guy, I think that, MGM's offering you a good deal. And he says, why won't you take it? And the guy looks at him and he says, I want justice. And the judge said, if you want justice, go to the temple tonight. This is a courthouse. You're in the wrong house. You don't want justice. Get it? Just remember that. I mean, how can you, I'm sitting there going, I almost fell out of my chair.
You were representing MGM, they must have been offering a lot of money.
They were. Actually, it wasn't MGM, it was Sony.
Even
Because MGM sold, originally they sold to Columbia, and then Columbia sold to Sony, but they're still in the same shoes. Yeah, we were offering a lot of money.
It must have been a lot of money.
Yeah, we were offering a lot of money. And it settled. I mean, the guy, it was a terrible case. And he was a really, he was like a director or, a substantial person who had the possibility in the future of making lots of money. And now he was screwed. I mean, the injury, just what I told you, was terrible. But on top of that, this guy had a huge upside on what he could earn. So, I mean, we wanted out of this case in the worst way. And I mean, the problem wasn't just that the stairs were bad, because your grandfathered in for old stuff, okay? But they were like cement stairs that were really slippery, and there were no anti-skid things on them, and that doesn't have to be by code. That's just common sense. What's a standard of care for you got slippery stairs? You put an anti-skid strip on it at least, and there was none. And so this guy takes a tumble and his life's screwed. Okay, so what this chapter's about is, if you're a lawyer and somebody comes into your office, should you take the case?
Yes.
Okay. Why are you saying yes?
For you, in this situation.
You mean, yeah, for
Representative
this one, either side, you take this case.
Yeah.
But what they're talking about here pretty much is, if you're if you're a plaintiff's attorney and somebody comes into your office, what are the factors that you should consider, okay, before taking the case? And should you take it? I mean, just because somebody walks into your office and says, I want a lawyer, doesn't mean you're gonna take his case. All right? Now, the practice of law is somewhat different here than it is in LA. I haven't practiced now full-time or at all for 10 years. I just do mediations. So I'm still in the game, and I know how much cases are going for and what attorney's fees are. But when I was practicing, and because I defended lawyers in malpractice cases, I was asked to speak at seminars on how to avoid malpractice, okay? And this has nothing to do with malpractice necessarily, but based on how much it costs to litigate a case, I basically told attorneys, if you don't have $100,000 in damages, or you don't think you can prove $100,000 in damages, don't take it. Tell them you're too busy. Your calendar's full, and tell them that, go to the county bar and ask for a referral. I wouldn't refer it to anybody else, but it's just not worth it to you unless you're working on an hourly fee. Okay, and this guy wants to pay you an hourly, and you tell him our fees could be more than $100,000 by the time we're done, and it won't be worth it to you. And the guy says, I don't care, I want justice. All right. In which case, you've got to put all of that in your retainer agreement. Right? You got to put in your retainer agreement. He doesn't care how much this thing costs. Okay? So you guys will remember that, right? Yeah. All right, let's take a break. I'm gonna have my delicious dinner.
What do you got tonight?
Same thing as I had the last time. Got my delicious dessert. I've lost 6.5 pounds.
Oh, nice.
That's something. Okay. Well, I'll go give Veronica the bad news.
They didn't make it too quick.
also remember that he didn't sit off. Yeah.
See, you threw me off. It wasn't fair because you said black.
we did, my first time,
You might be on the wrong path.
I could have been like Japanese.
Within here. Oh, I think. Is that Daniel? I got it. Like, number one, Dina. Like, why? She was so emotional. I'm like, can I have any answers? It's because I did not get class.
Okay, it was student offenders? Oh, I thought it was student offenders. Okay, so. I'm too easy. Okay.
I know, Roger comes up to me, Dina. I'm like, oh.
No. Okay. So, first of all, litigation in the United States. This is covered on pages 301 and 302. The takeaway is court cases go to trial at a higher rate than contract cases. And when they do go to trial, it's more likely to be a jury trial. And the plaintiff's win rate is around 50%. What do you think of that? Means you got a 50-50 chance of winning if you go to trial. Do you like those odds? That's why more and more people are going to mediation now, because they want to settle their case. All right? Those are pretty crappy odds. The reason they want a jury, though, is that juries are more likely to give, if they find liability, they're more likely to award more money than a judge. Okay? And in a breach of contract case, the parties usually want a judge because the issues are usually interpretation of contractual language or provisions. And that's something that would be better handled by a judge than a jury because it really involves legal issues. And juries aren't particularly interested in them anyway. They don't get excited about breach of contract unless it's something highly unusual. Okay. When a plaintiff wins, so these are nationally, when a plaintiff wins in a tort case, the median recovery is less than $45,000. So you got a 50-50 chance of winning, and you may only get less than $45,000. Do you like those odds if you're a plaintiff's attorney? You do all this work, and you're gonna get a third of $45,000? That ain't much of a paycheck. Okay. Contract cases go to trial less. And when they do go to trial, it's more likely to be before a judge. And plaintiffs prevail about 2/3 of the time, winning a median of around $45,000. Now, again, these are national averages. In California and I'd say on the East Coast, in the industrial East Coast, probably be more than the national average. But how much more, I'm not sure. Not a lot more. So what that's telling you is that there are a lot of two-bit cases going to trial. And the attorneys aren't getting that much in the tort cases. And in the breach of contract cases, they probably are, because in most breach of contract cases, the clients are paying by the hour. Most lawyers will not take a breach of contract case on a contingency. So that the attorneys don't care if these idiot clients want to go to trial on something that's probably worth $45,000 and they're billing by the hour. They don't care. They should. They should be banging on their clients, telling them, don't do this. But at any rate, these are things for you to think about. So, in federal court, how many civil cases go to trial? 5%. Okay. So why are we studying civil procedure, federal civil procedure at all? What do you think it is in California?
10%?
10%.
Is that right?
It's still nothing, right? What, so why are we studying this?
It does.
For the 10%, for the times.
Why are we studying federal civil procedure or California civil procedure if only 10% of these cases wind up going to trial? Huh?
It's on the bar.
That's right. And the bar examiners require that it be taught. Okay. Now, there are some good reasons about federal civil procedure, even though very few state court lawyers wind up going to federal court. And that's because, number one, the federal system is throughout the United States. Okay? And so the American Bar Association wants lawyers all over the country to be familiar with the courts that are throughout the United States. The system that's throughout the United States, our federal system, right? Secondly, most state systems now have their own civil procedure systems that mirror federal systems, so that if you're familiar with the federal system, you'll also understand most state systems, okay? And it's on the bar exam. So, what are the factors that you should consider when a client comes into your office and he's got this hot case that he wants you to take? The first one is, and most important, what are the remedies that are available to your client? The most important one is compensatory damages. What's a case worth? Okay, you have to be able to listen to this client and ask the right questions to determine whether or not this case is going to be worth your time or worth his or her time to litigate it. So if it's a tort case, you're going to ask questions like, and you'll get this all the time, so you'll just get friends who call you up too, and they'll say, this doctor really screwed up. And I've been to see this doctor this many times, and he didn't catch this, and he didn't catch that, and he should have done this, and he should have done that, and my leg's all messed up. And do you think I've got a malpractice case? Well, I mean, based on what the person just told you, you'd think, wow, this sounds pretty good, right? So then the next question is, well, so what do you mean by your leg's all messed up? Well, you know, we did all these procedures on my leg to remove, it was skin cancer, and they removed it, and finally they got it after 4 or 5 times, and I got bandages all over, and it's starting to heal, but it's really messed up, and does it look like it's going to heal? Yeah, eventually, but he's really screwed up, and he put me through all of these procedures. And the next question is, so did you lose any time off of work? No, I don't work. Okay, okay. How much did it cost an attorney in medical bills? I don't know. I have Medicare. Well, how much did you spend? I didn't spend anything. Okay, this is a phone call I got, and I said, well, in order for there to be malpractice, one of the elements is that you have damages. So what you're telling me is you've got emotional distress. Is that what you're telling me? Right? Yes, I'm very distressed. I'm very upset. Can't you tell? And I said, well, he's gone to see a therapist. I'm not crazy. So you didn't see anybody. No. So you haven't spent any money and you're not out any money. Is that right? Is that what you're telling me? Yes. You don't have any damages. You don't have a case. What? You're going to get this all the time, okay? That's the first, but this is the first, these are the kinds of questions you have to ask people. They may be upset about something and they want justice. But they got to have damages. Okay? And then the next step is, how much are the damages? And they tell you, well, by the time they're done, it's like $1,000. Right? It's an auto accident, it's $1,000. What should you tell them?
Not worth it.
Insurance.
Well, you say, why don't you go to a small claims court? You don't need to go to a small claims court. You can file it on your own. And they won't have a lawyer either. And you don't have to worry about an insurance company trying to beat you up. Just go to small claims court. That's it. $1,000? It's not worth it. Okay. So, the things that you should be thinking about are the amount of damages first. And second, how are you gonna prove liability and damages at the earliest possible time during the litigation? A low damage case merits litigation if the facts are simple, which means it's not gonna cost much to prove. Okay? And it looks like the merits are strong. That means it's a good case on liability. And there's a fee shifting statute in effect. You know what fee shifting statute is? It's in the chapter. Attorney's fees. Okay? And there's attorney's fees. Okay? Then even if it doesn't seem like the damages are great, if there's an attorney's fees statute covers it, usually even $1 can get you attorney's fees. Now, caveat, if you just win $1, you submit this gigantic attorney's fees bill to the judge who's going to award it. You think he's going to give you a big fee? Because he's the one who decides. You can say, you know, I billed out $300,000 on this $1 case. But you think the judge is going to give you $300,000? No. He's going to say, what were you thinking? You know, he'll give you something, but he's not going to give you a big fee. So you have to take that into consideration. There's also liquidated damages, statutory damages, and punitive damages. So you know what liquidated damages are, right? In order for you to get liquidated damages, you have to establish that there are actual damages which are difficult to prove, and the amount must be reasonable in light of the anticipated harm. Then again, if there's liquidated damages, it may not be a lot of money. It may not be worth it. I mean, if liquidated damages are $10,000, might not be worth it. Then you look again at statutory damages and fee shifting statutes for attorneys' fees and costs. In federal law, one of the things to remember is in a civil rights case, if you win as a plaintiff, you get your attorney's fees. Okay? Trish has heard this one before, but I've cut it way down. But so I had my last case was as a plaintiff's attorney in a civil rights case. Okay? I get a phone call from a lawyer up in Stockton, and she had been my client in a malpractice case. And she knew that I had taught con law and was a public defender. And she said, I got a civil rights case I think you might be interested in. And I said, okay, tell me about it. And she said, well, the client is the richest guy in Amador County. I said, sounds interesting. Said, I'm interested already. And she said, well, and they charged him with like 19 felonies, and his lawyer got it thrown out. Okay? And it was dismissed by the court up there in Amador County. And it was thrown out for lack of probable cause. Okay, it's a search and seizure search warrant case. And the public defenders know anything, it's search warrants. Okay? Because that's how you get rid of a lot of felonies. I mean, all the drug cases, your only defense usually, it's either you try to get rid of it for lack of probable cause, or it wasn't my guy's stuff. There's only, basically that's it. So you learn Fourth Amendment search and seizure law backwards and forwards. I said, okay, sounds right. Why don't you send him on down? So he drives on down, and they had emailed me copies of the search warrants and the judge, and a transcript of the judge's ruling, throwing it out. Okay. And so I sent it over to a friend of mine who's a civil rights lawyer. After I read it, and my take was, these are the worst search warrants I've ever seen. I mean, it wasn't even close. And he calls me up, he says, dude, these are the worst search warrants I've ever seen. He says, this is a good case. And they had issued, I think it was 14 search warrants, most of which were for his office, which was in his home. And they basically took almost every stitch of paper they could find in his office, including stuff that wasn't listed in the search warrants, like, family photographs. He was working on a family tree where he had been driving all over the country interviewing people with the same last name. And it was like this big. They took the family tree. It was up in the Amador County, is in the gold rush country. So he had a gun collection of 15 guns. They took all of the guns, which had nothing to do with the offense that they were investigating, which was an environmental hazard allegation. And he had incurred $55,000 in attorney's fees on the criminal case. So what's that worth other than $55,000 on the attorney's fees? Based on what I just told you. Oh, and they lost most of his records.
Value of the guns?
Huh?
Is it the value of the guns?
What about his business records and family pictures and the family tree? What's that worth? What do you think?
I shoot high, but I'd say $10 million.
That's high. What do you think?
I don't know, I'd say 1.
1 million. What do you think?
Or just quadruple his attorney's fees.
Quadruple? No. The attorney's fees are different.
Yes.
We're talking about what's damages for what I just described, not attorney's fees for the lawyer who handles the case, which is going to be me. If you go to trial, what's a jury going to award this guy?
$5 million, maybe.
You say 5 million. You say $1 million?
No, maybe a little more, 'cause he did all that, driving around, maybe
Yeah,
3.
Driving around, what?
driving around all over the
For
United
family
States
tree.
for the family tree.
Okay, what do you say?
5 million.
What do you think, Trish?
I'll say 500,000.
Yeah. What do you think, Clara? I can't hear you. Still can't hear you. Turn it on. Jesus Christ. It's like having my wife in class.
Can you hear me now?
Yes.
Now? Okay.
How much?
I was agreeing with Trish. I was looking at about 500,000, the uniqueness of this.
So it's all over the place, right? Who the hell knows what this thing is worth?
Depends how pertinent the business records were to him and.
They weren't. I mean, they weren't. But, all right, so like his tax, if they had all of his tax returns. I mean, I wouldn't like somebody getting all my tax returns and losing them. But
So I have a question.
But
So-
how are you hurt by losing these records?
Well, is it a Fourth Amendment issue?
Yes.
Okay.
So we're gonna win on that. Trust me. We've already decided by looking at this, we're all experts in Fourth Amendment. The cops completely screwed this case up. And they did it, and they did it maliciously. Okay? The Indians wanted to put in a casino up there. This is a county that's about as big as Riverside County, but it has 85,000 people in the whole county, right? The county seat is a town called Jackson that has 5,000 people. That's the biggest city. Okay? And the Indians wanted to put a casino right outside of Jackson. Okay? Now, what happens if the Indians put a successful casino right outside of Jackson?
Attracts people.
Huh?
Attracts people.
Yeah, they make a lot of money, right? So who becomes the 1,000-pound gorilla in Jackson? The Indians, right? So the county supervisors who are all in Jackson don't want the Indians to put in a casino. And in order for them to put in a casino, they had to go outside the reservation to get some land to put in a parking lot. Okay? Without that land, they couldn't put in a casino. So nobody in Jackson who wanted to incur the wrath of the Board of Supervisors would sell their land to the Indians, except my client. So my client, Bob, he's like a, he's further to the right than the Republicans. I don't know what you would call him. I mean, he's like a real extreme right winger, where we definitely became the odd couple, but he's totally anti-government. And so he said, fine, I'll sell them the parking lot, the property for $100. So he sold them the land for $100, and they put in the parking lot, and needless to say, the Indians became the 1,000-pound gorilla in town. It's a huge casino. It's like Agua Caliente. Okay, yeah. So they don't like my client. And when they got a chance to get him, they got him. Okay, and it was total BS. Still, what's it worth?
There's a lot of factors, right? So if his Fourth Amendment rights were violated, how do you quantify? Because the purpose of punitive damages is to punish
Those guys.
and how do you punish large government? You know, what's an amount? What's a
And
quantifiable
so,
amount?
and so who are we suing? We're suing 2 different county district attorney's offices and their lawyers.
Yeah.
Okay, and the CHP.
So it's gotta be a.
And because the CHP are the people who wrote the search warrants and executed the search warrants, okay? And the state of California, and it's venued in Sacramento. That's why, and it's a big publicity case up there, and that's why he's coming to me, because nobody will take it up there. Because they don't want to cross the CHP or those DA's office, okay? So it comes down, I like the case, but we don't know what it's worth. And civil rights cases are really time consuming, and they can cost you a ton of money if you're the lawyer. And if the governmental entities want to screw with you, and the state can definitely screw with you, okay? Who cares about these counties? The state, the state's got attorney general on it, so they don't, they don't have to worry about anything. They're not paying attorney's fees. They've got guys who are salaried taking care of this thing. They'll run it up and down, take you up and down. The Ninth Circuit as long as they can. So knowing that, and knowing that these things can take years and you may get nothing. I meet with him, and he tells me his story, and I said, fine. I'm testing the waters, and I said, I'll take the case for $100,000 up front. Thereafter, we'll bill against $100,000 until we consume it, and then it'll be on a contingency. Okay, 30%. Unless it settles. And if it settles, I'm sorry, 40% of it goes to trial, 30% if it settles. Okay? So he pulls out a checkbook and writes me a check for $100,000. Would you take that case?
Yeah.
Right?
Yeah.
Yeah, right? And you explain to him, I explained to him, I said, I don't know what this thing's worth. Nobody knows what it's worth. We can't quantify this. I say, who the hell knows what your property's worth? He says, I said, what is it worth to you? He said, it's invaluable. I don't know. And I said, okay, what do you want?
I have a question.
Okay, then the next thing you ask your client is, what do you want? He says, I want them to pay your attorney's fees. I said, that's it? He said, that's right. He said, I told these guys from the gate, just pay my attorney's fees for $50,000. And we're done. They wouldn't do it. So that's why I'm in your office. All right, so you write all that stuff up and you put it in your contract. Okay? Yeah, now your question.
So what happened in the criminal case?
They got thrown out.
They got thrown out?
Yeah, at the preliminary hearing. The very earliest part, where the court rules on whether or not there's probable cause. And this old judge from Modoc County or something, they had to bring in this judge from another county because all the judges in Amador County were on the tape from my client. All the judges, there's like 3 judges. No. So my client contributed to all the campaigns, so they disqualified themselves. Anyway, we'll talk about that later. But it took 7 years. 2 appearances in the Ninth Circuit Court. Okay. $1.44 million in attorneys.
Wait, what was that? I didn't hear that. It was 1.4 million, you got?
I billed out $1.4 million in attorney's fees on an hourly rate of $350 an hour for me and
Wow.
$250 an hour for my associates. and $100 an hour for my paralegal. That's how much work we do. Okay?
Can you count the damage, for his arrest and the criminal charge against him for?
That's what the 55,000 was for.
Well, yeah, I understand for attorney's fees, but could you claim in punitive damages that it was damaging to his reputation?
Bob's reputation.
Yeah.
Uh,
As a business owner or whatever he does?
I don't think you want to get into Bob's reputation.
I don't know, Bob, I have no idea.
No. Bob, it's the kind, one of the things you get into is if you get into his reputation, some people say it's sterling. But the people who hated him, they're gonna, they were claiming that he was mob, that he was a mobster, that he was a drug dealer. How else could you get all that money other than Amador County? You had to be a drug dealer? I'm serious, He was gonna sell his house for $1 million up there. Doesn't sound like that much, does it? In Southern California. I mean, it's something, but $1 million doesn't sound like he's a big player, does it? In Amador County, $1 million is a lot of money. I mean, you're talking about houses that are selling for, $125,000. So this guy's selling his house for $1 million. And when he put his house up for sale for $1 million, it made the local newspaper. Front page with pictures of it. So, I mean, somebody who has a house like that has to be a drug dealer. No, you don't want to get into that. Okay, so we'll get back to that case later, all right? These are the things you have to think about. Now, in California, how do you get attorney's fees? Because it's not a civil rights case. In California, how do you get attorney's fees? Ordinarily, you don't get attorney's fees. Did you know that in California? Basically, unless it's by statute, and there aren't that many statutes in California that give you a right to attorney's fees. It has to be by contract. So it's basically a breach of contract case. Okay? If you've got a breach of contract case where the contract awards attorney's fees, then the prevailing party gets attorney's fees. So one of the issues becomes, what's a prevailing party? I've been doing a little expert witness work on attorney's fees. Okay, but I got involved in this one case where at the end of the arbitration, the arbitrator who used to work for the plaintiff's attorney, the defense attorney, as a paralegal before she became a lawyer, didn't disqualify herself. Okay, but anyway, the arbitrator awards the guy that I was testifying for $2,500. So that means that he won, right? He should be the prevailing party. So she awarded the other guy attorney's fees as the prevailing party without any explanation. So that's up on appeal. What's a prevailing party? If it's in an arbitration, it's usually not subject to appeal, so that would be interesting. Okay. prevailing party means you usually are the winner. But I guess in this case, she was saying, well, it was so little, $2,500 that the other side really won. Okay. What you do get is statutory costs. Doesn't sound like much, does it? It's usually costs of depositions, filing fees, expert witness fees, but not attorney's fees. So in California, if you get costs, that's what you get it for. You cannot get attorney's fees unless there was an attorney's fees clause. So I wound up representing a law firm, a big law firm in LA, who was suing big real estate developers who they had represented in a series of arbitrations. And they basically got the clients everything that they wanted. But the big developers, who were also lawyers, and one of whom was in my law school class and was #1 in the class, okay, and was a real peach of a guy. When his attorney, who knew me from law school, introduced me to him, we never knew each other in law school. There's like 300 people in the class, so you could wind up not knowing someone. The guy looks at me and he says, I was ahead of you. And I thought he meant he was a year or two ahead of me. And I said, what year did you graduate? He said, 69. I said, so did I. What do you mean you were ahead of me? He said, I was ahead of you in class. I was #1 in class. And I'm thinking to myself, what an asshole. Yeah, pardon me, that's illegal. Right? So you get an idea of what this guy's gonna be like in front of a jury. So anyway, they build out like $500,000 on this case, but we're talking about a huge development on Hollywood Boulevard, okay? And it was, hundreds of millions of dollars involved. And they got what these guys wanted. And so the attorney's fees were like $500,000. And they paid them like $240,000 and then they stopped. They just didn't pay the rest. So my client, the law firm, says, we want you to sue these guys for the $260,000. I said, well, juries don't like lawyers and law firms. They're not going to be particularly sympathetic to your cause. And they said, well, we don't care. We can't let guys like this get away with stuff like that. If they know that, if people out around town know that we're just going to walk away from $268,000, then we'll have other clients stiffing us. So go for it. So we filed this case in downtown Los Angeles, which is predominantly minority, you would think predominantly not like a big law firm, right? And this would not be a great venue. So before we go to trial, I tell my client there's a statute in California where you can make a demand, a statutory demand to settle. And if you come in with a verdict that's more than what you offered to settle, then you get your costs. Okay? And I said, so make a demand of $175,000. And they said, what? That means we're giving them like $100,000 discount. And I said, they're not, these guys are assholes, they're not gonna take it. And then you can get your costs if we get more than $1 more than 175,000. I said, okay, we did it. And of course, these guys blew us off. We go to trial, and number one in his class is on the stand. I'm cross-examining. I go through the litany of all the things that my guys did for him. And he got you everything that you wanted, yes. And I said, and then you stopped paying, isn't that right? And he said, that's right. He just said, that's right. I paid enough. And I looked over at the jury, and they're all going, I paid enough. And my argument to the jury was, because all these people were working people, I said, assume that you did a job for somebody and you did everything that you were supposed to do, right? And you submitted your bill, and the guy stiffs you half of the bill because he didn't feel like paying the rest. He paid enough. You think that's right? And they came back with $268,000. Okay. The judge then awarded us costs of $250,000. Unfortunately, I didn't do this on a contingency. Okay, that's what they're talking about when they say fee shifting provisions. Okay, if you got a fee shifting provision in your statutes, then that's a factor to take into consideration when you're taking the case. Again, in both of these cases I'm telling you about, you notice I said to the client, we don't know how much it's worth, what do you want? And you just lay it out. You lay out what, and you think that this could be expensive, yada, 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 okay? So, knowing that, we got our first case. Winter versus Natural Resource Council on page 61. Do I have the right page?
361?
What?
You said 361?
361? What's the page?
361.
Yeah.
Yeah.
You want to do that?
That's the Buckhannon.
Winter versus Natural Resource Council. You want to present that?
Are you go?
Huh?
You said 361, is that right?
I don't know. What page is Winter on?
Winter, well,
Huh?
winter, we had Buckhannon.
Maybe I didn't have it. Did I not put this in the reading list?
We have Buckhannon.
We had Buckhannon Board and Care Home versus Western Virginia Department of Health and Human Resources.
Just a minute. Okay, I don't know where I got this. Forget that.
Yeah, let's see one.
Okay, next, provisional remedies. And due process. We have Fuentes versus Chapin, right? No?
We only have one case,
You only have one page,
one case.
one case, what is that?
Buckhannon Board and Care Home versus West Virginia Department of Health and Human Resources on page 361.
What have I done? Let me look at it.
You probably anticipated that we were going to go over the exams, and that's why you only assigned one case, I bet.
Well, I must have known what I was doing. Oh, I see. Okay. So who wants to tell me about Buchanan?
I'll do it.
Huh?
I'll do that.
Oh, this is a new book, that's why. I didn't change my,
Freaking out.
I didn't change this outline. This is from a previous book. This is a new edition. That's better. I like this better. Okay, tell me about this case. This will be all new to me.
So, plaintiff here is, Buchanan Ward and Care Home Inc., the operative care homes and the provided assisted living to their residents. They violated a state regulation that required residents to be sufficiently ambulatory to get out of burning buildings, so I assume they forgot to put a ramp on the building. So Buchanan and other similar West Virginia facilities is sued and alleged that the state regulation violates several federal housing and disability statutes. So they sought injunctive and declaratory relief. And defendant West Virginia Department of Health and Human Resources, they halted enforcement of the cease and desist orders, pending resolution of the case and parties began discovery. So in 1998, the West Virginia legislature enacted 2 bills eliminating the self-preservation requirement, and the plaintiff responded by moving to dismiss the case as moot. And so the district court granted the motion, finding that the 1980 legislation eliminated the provisions, and there was no, and because there was no indication that the West Virginia legislature would repeal the amendments. And so, in response to plaintiffs, they requested attorney's fees as the prevailing party under FHAA 42 U.S. Section 36.
Right.
They argued that they were entitled to attorney's fees under the Callis theory, which causes that a plaintiff, the prevailing party, if it achieves the desired result because the lawsuit brought about a voluntary change in the defendant's conduct.
Right.
So that became the issue here, whether the term prevailing party includes a party that has failed to secure the judgment on the merits or court-ordered consent decree, but has nonetheless achieved the desired result because the lawsuit brought about a voluntary
Okay,
change.
slow down. Read that again slowly.
So whether the term prevailing party includes a party that has failed to secure a judgment on the merits or a court-ordered consent decree, but has nonetheless achieved the desired result because the lawsuit brought about a voluntary change in the defendant's conduct.
If a voluntary change?
Voluntary change.
Okay.
The rule I took from you was on page 362. The court says that in addition to judgment on the merits, the court held that settlement agreements enforced through a consent decree may serve as a basis for an award of attorney's fees. These decisions taken together establish an enforceable judgment on the merits, and court-ordered consent decrees create the material alteration of the legal relationship of parties necessary to permit an award of attorney's fees.
In other words, you don't have to go to trial and get a verdict.
Right.
If you get a good settlement that results in a voluntary change on the part of the defendant, that can constitute prevailing party, right?
Right.
So what were the attorney's fees?
The attorney's fee, they said, I didn't see a number.
Yeah, I don't think there was a number.
They didn't tell you?
No, there's no
Okay.
one on here.
So I'll give you an example. Have a seat. Very good. So now we know, if you get a good settlement and the defendant agrees to do something that's in the public interest, usually, then you'll get your attorney's fees in federal court. All right? A friend of mine in LA, went to, all the good schools on the East Coast. Went to boarding school and Yale and Harvard Law School, and went to work after law school for one of the big law firms in downtown LA. And after a couple of years, he and some of the guys from the law firm decided to take a risk, and they opened up a public interest law firm. where they would take public interest cases, but the public interest cases usually, that they were handling usually dealt with housing and things like that, but not necessarily. I mean, they would do stuff like lawsuits to protect the homeless. Okay, but that's a big risk because usually the clients aren't going to be able to pay you, so you're hoping that you're going to make a lot of your fees off of court-awarded attorney's fees in these cases. So they wound up handling a lawsuit against the state of California and the county of Los Angeles, who were putting in the, God, I can't think of the number of the freeway, but it's a freeway that runs from LAX to Norwalk. 134, I think. I'm not sure. Anyway, no, the 105. Okay, so 105. Well, the problem with the 105 was that in order to put the 105 in, they were going to have to use eminent domain and basically take away the housing of a large segment of low-income families. So they sued on behalf of these low-income families that were going to be in the path of this freeway, the majority of whom were either Latino or African American. Okay? Well, so they wound up getting a consent decree out of the state and the county that they would pay a certain amount of money per household for their property that was closer to market value than just, coming in and saying, we're exercising eminent domain, we're gonna give $50,000 for your house. And in addition, that they would run light rail through the center of the freeway, which had never been done before in LA County, except from Long Beach to downtown. But that was just voluntary because when they were building the freeway, they did that. Okay, but the proposal to build that freeway had nothing to do with light rail. Prior to this lawsuit, the only light rail in Los Angeles County was running from Long Beach to downtown LA. That's it. So they got this consent decree, and the judge awarded them $3 million in attorney's fees. Okay? Now with the $3 million in attorney's fees, they bought themselves an office building on the west side of Los Angeles for their offices. And they were on the 3rd floor, and then they rented out the 1st and the 2nd floor. The 1st floor was rented out to a bank and a bunch of other businesses. And their law firm took off. Okay? That's it. None of this will be on a test except punitive damages. Punitive damages. Okay. There's a case called BMW versus Gore. 517 U.S. 559, that's a 1996 case. The Supreme Court held that grants of punitive damages are subject to judicial review, and that punitive damages under the Constitution, under due process, cannot be more than 9 times compensatory damages. Okay, that is the subject of testing. You will see that on multiple choice questions. Okay? So based on all of the stuff that we just talked about, the takeaway is you don't want to take a case unless you know you're going to get some money out of it. And if the damages don't look like a lot, look to see whether or not there's attorney's fees and costs. And if they're punitive damages, you can only get 9 times compensatory. So if the compensatories are $5,000, you want to take that case?
Wasn't there a State Farm case too? I forget what the citation is, but it was like the guy had, it was like $1 million in damages against State Farm, but then he got awarded $100 million in punitives. So then they awarded that amount was excessive.
What, they did what?
They awarded him $1 million in compensatory damages and then $100 million in punitives, and the court ruled that was excessive.
Yeah.
But I think I did an analysis on this for work actually, and
Under Gore, that means the most he could get is 9 million. I mean, yeah.
yeah, I'll look to the language, but I don't. My opinion was that there isn't a hard rule set for 9 times. It
No,
depends.
that's a hard rule.
I don't think so.
Huh?
I don't think so.
Why?
I'll bring in my analysis. I did it like 6 months ago with the attorney that works. We outsourced to our attorney. Anyways, I'll bring it in because it's interesting.
You found a U.S. Supreme Court case that says
We
that,
looked at BMW and at State Farm, and if you look at the actual language of that the court rules on in their opinion, it says if it's excessive, I don't know. I have to look at the actual language, but my interpretation of the language isn't that means that it's 9 times. There's nowhere verbatim that it says it's 9 times.
9 times, if you look at all of the cases that have gone to the Supreme Court,
Mhm.
They have not approved any grant of punitive damages that's in excess of 9 times. And in practice, judges throughout the United States are cutting awards if they're more than 9 times.
Yeah.
I mean, there's a difference between analyzing the language of the case. The case seems to indicate that 9 times is the guideline. And if it's more than 9 times, it would be excessive. It doesn't say 9 times is excessive. That's true. But in practice, the courts.
It all depends on the circumstances, I think. So say if you are in a contract with Apple or Microsoft or something for a contract and they breach the contract and say the damages are $300,000, but there's a lot of fraud behind it. What would be the amount to deter a company like Apple or Microsoft from doing that again? It wouldn't be 9 times. It wouldn't be $4 million. Apple would piss on $4 million. It would be much more than 9 times.
We'll see how the Supreme Court rules.
Yeah, no, I know. I just don't think that there's a hard rule saying.
If you
that
now
there's-
have 5 conservative Republicans who are pro-business, what do you think?
We stick with 9 times.
Yeah.
Yeah.
I mean, just remember what Justice Black says. The Constitution means what 5 justices say it means.
I just think it's super interesting.
Yeah, it is interesting. But you gotta temper interpretation with practice.
Yeah.
Just remember, if you see an exam where it's more than 9 times,
It's excessive.
it's 9 times.
Thank you.
Bye, guys.
I know, we could have,
We could have done
literally that 10-minute, like, multi-round, we could have finished.
that. It's so funny that just happened.
The community damage.
Yeah, it's just been like a hot ticket item. Like it's always.
There's plenty of cases in contracts where community damage were huge.
Yeah, the trial court, but then when it goes to the appellate court,
Oh,
they
that's
will,
true.
but it's all